Pursuant to RCW 7.70.030, the plaintiff must prove that damages from an injury resulted from the failure of the healthcare provider to follow the accepted standard of care, that the provider promised the patient that they would not suffer the injury that they did, or that the injury resulted from provision of healthcare for which the patient or their representative did not consent. Medical negligence is medical malpractice. If a plaintiff sues under a medical negligence theory, they must prove each of 4 elements in order to prevail. The plaintiff must prove these elements on a more probable than not basis once all conflicting evidence has been weighed. The 4 elements are duty, breach, causation, and damages. In other words, the medical provider had a duty to adhere to a known standard of care. The medical provider breached that duty. The breach of that duty then caused the plaintiff damages that could not be mitigated. Alternatively, a plaintiff may sue based upon a lack of informed consent. Under this theory, it is not necessary to show that the medical provider breached the applicable standard of care. It is only necessary to show that if the plaintiff had been provided full information, they would not have consented because they would have chosen an alternative medical course, perhaps even including non-treatment. If you have questions about whether to file a medical malpractice case versus an informed consent case, or any other inquiry related to medical malpractice in general, please consult the experienced attorneys of Washington Law Center.